All right. Criminal. Week 2. We're going to be talking about criminal law and the Charter, criminal law and the Constitution, ultra vires, components of criminal law, Henry Morgentaler, the codification of criminal law. We're going to be talking about common law offenses and common law defenses. So, criminal law and the Charter. Why is the Charter important? Because it enshrines our basic rights relating to search and seizure, innocence before the law. We have the right to be informed promptly in the reasons for our detention. We have the right to be secure against unreasonable search and seizure. Those kind of rights. And when does the Charter apply? The Charter only applies if the Superior Court is hearing the case. And thus, common law matters more than Charter rights sometimes. But the Charter doesn't apply all the time. Section 1 of the Charter states that the Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So we're guaranteed these rights subject to the reasonable limits which can be justified. So they don't apply all the time. If you are arguing a Charter violation, the burden of proof lies on you, and thus it is sometimes easier to argue against the issues that the other side has the burden of proof for. What is a Charter remedy? When a person's Charter's rights have been violated, the remedy is generally that the resulting evidence will not be admitted. However, this is also limited. If the judge feels that the exclusion of the evidence will challenge faith in the administration of justice, then it may decide to include the evidence, despite the fact that it was obtained by infringing on your Charter rights. Constitution and criminal law. Criminal law is federal, the administration of justice is provincial, and property and civil law are provincial matters. Ultra vires. This is with regards to a law being passed by a certain jurisdiction that doesn't have that jurisdiction. So, for example, a province passing a law on with regards to assault. That is obviously a criminal law. It's a federal jurisdiction. They can't pass the law. If they do, they'll be considered ultra vires. Likewise, if the federal government passes a law on the licensing of pets, that's not their jurisdiction. That's a property and civil matter, and thus that's the jurisdiction of the province. And that's why they're unconstitutional. If they're outside the jurisdiction, they're unconstitutional. If we look at the Schweitzman versus Elving case of 1975, also known as the Padlock Act, this is an example of a province enacting what was considered a criminal law, and it was thus declared ultra vires by the Supreme Court of Canada. The law allowed the provincial government at the time to padlock the door of anyone they thought was a communist or a communist agitator, and someone leasing an apartment in the same building as someone who she thought was a communist agitator, and she was concerned her door would be padlocked, brought this case to court. We can look at the Reference of Firearms Act in Alberta. Here is where a law with regards to firearms, a federal law, was challenged in the sense that it was infringing on the provincial jurisdiction of the property and civil rights and the administration of justice. So there are many things which are licensed, for example, that are not criminal matters, such as fishing licenses, driving licenses, etc. These are legal issues and they're administered by the province. However, the federal government enacted a law requiring the registration and licensing of firearms. Now, from the provincial point of view, a firearm is exactly like a car. When used appropriately, it's not dangerous, it's not a criminal issue, it's for the benefit of society, and therefore it should be a provincial matter. From the federal government's point of view, it's more like cocaine. It is inherently damaging. No matter how you use it, it's going to damage something, even if it is for the general good of the public, for example, hunting for food for your family. They said that guns are inherently dangerous, that and it is thus a criminal matter. The provincial government also argued that it's an unjust infringement on people's privacy. It's also worth noting that this comes in the wake of the Montreal massacre, so this was a policy, I guess, context for this law. The Supreme Court of Canada decided that the efficacy of the law is not relevant. It doesn't matter if it's going to work or not. And the cost of the law is not relevant. It doesn't matter if it's going to cost a lot or not. And eventually decided that the law, I'm not sure what they decided. I believe they decided that the law was constitutional. What is the mending formula? 80% of the provinces and 15% of the population if you want to amend the Constitution. Though it will likely never be amended in our lifetime because there's too many issues that remain unresolved. Components of criminal law, there's the harm element, the actus reus, and the intent, the mens reus. You have to prove both of these elements in order to be convicted of a crime. Components of criminal law, it's also been defined as prohibiting a certain act and providing a penalty for that act. Morgentaler, there were a number of legal issues in the documentary watched on Morgentaler with regards to him flaunting his breaking of the law against abortion. So some of the legal issues were the pre-trial issues. The lawyer stalled the trial as much as legally possible. He didn't break any rules, but he stalled it as much as he could in order to let the public sentiment against Morgentaler fade away after he publicly aired an abortion on Mother's Day. Whenever they came in to arrest the Morgentaler and the other people, they were upsetting the patients, and there may be a tort action for emotional stress. There was also a scene where the police said, you have to answer the questions, which may have been an infringement on their charter rights. And there's the issue of when the prosecutors decided to go collect evidence. If we come down to the bottom point here, there was a lot of surveillance going on. There was search and seizure, and presumably they decided that this is the most opportune time to collect the best evidence. But they can't just go collect anything. When they get their warrant, they have to say that it is in the hopes of finding XYZ, and there must be reasonable probable grounds for finding XYZ. So the harm principles, some of the police officers were concerned about Morgentaler because there were so many abortions happening at other less reputable clinics or in back alleys, and Morgentaler had a great reputation. So was he doing harm to society? And lastly, of course, when does a person assume a legal identity? And according to law, you don't have one until you are born. Codification. The codification was the reduction of the existing law to an orderly written system, freed from needless technicalities, obscurities, and other defects. And it was a very noble pursuit. We do have a criminal code. It is large and expanding, and filled with statutes created to deal with the more tangible, concrete manifestations of what the Constitution is meant to create. So the statutes in the code back up the intent of the Constitution and gives practical meaning to the Constitution. It is the expression of the Constitution. Sir John Sparrow Thompson, former Prime Minister and Minister of Justice, created the original criminal code in the 1890s. And Sir James Stephen tried to take the common law, codify England, and failed. Common law offenses, some examples are champerty. Let's sue someone and split the proceeds. You're not allowed to do that. Barratry, litigation for the purpose of harassment or profit, so ambulance chasing. Now, these common law offenses were abolished, I believe, in 1953 in favor of our modern criminal code. And this was because they felt that crime should be predictable. And if the law is changing a lot due to the common law decisions, then that is counter to the principle of fair notice. The criminal code is considered fair notice. We are expected to know the rules, and not knowing the rules is not a legal argument that will be given any weight. Common law offenses. We look at the case of Frey versus Fedoric. Is peeping Tom a criminal offense? He was caught peeping Tom. He was chased down the street. He was captured and taken back to the person's house. But ultimately the court decided that because it wasn't in the criminal code, they couldn't prosecute. And thus the legislator made a new law against trespassing at night. And again, they can only be created through statute because we desire certainty and we need to give fair notice to the general public regarding the laws. Lawmaking. Parliament in this case, because the courts can't reach into the common law to punish an offense that isn't codified, there is now a dialogue between them both. So the courts and government talk together in order to create the new law. And it's worth noting that if the federal government vacates the field and decides we're not going to make a criminal law about this, the provinces can't come in and just make a criminal law. So there's nothing the provinces can do about abortion. Common law defenses, what are they? If we look at the R versus Amato case with regard to entrapment, the Bud Etsy in the dissent said, he outlines important principles that are taken in subsequent case law. The administration of justice has been brought into disrepute. The court of public opinion would think that this is outrageous, it's entrapment. It's a persuasive argument that the common law of defenses live. So, the court is the guardian of common law defenses, and they can change them and interpret them differently as time goes on. In this case, the defendant was called repeatedly in order to sell the undercover officer cocaine, possibly threatened, and the issue of defining exactly what entrapment is arose from that situation. And Bud Esti here says it's entrapment, and we can define it as such. It's the court of public opinion would think it's outrageous. Now, the majority, however, agree that entrapment exists, but disagree on the facts in this case and decided that it wasn't entrapment. And that's what I learned this week in criminal law.